Hello, everyone.
Hello.
Hey, how are you?
Pretty good. I'll give it a few more minutes for more people to log on, and then I'll take roll. Well, since there's only a few of y'all on here now, I can start with what I got. Bria Pearson signing in. I'm gonna just wait because everybody's gonna be coming in. Every time I start, I'm gonna start back over. So I got Bria Pearson, Colson Parks. Is that you, Cole?
Yeah, that's me.
All right. Genevieve, what's your last name?
Ribeiro Yamasfield.
Waiting for pairing. Paired.
Oh yeah. How do I say it? It's Ribeiro Yamofio. How do
Yamasfield. It's Yamasfield, but you can just say Ribeiro.
okay. I just want to make sure I'm getting it right. You know what I mean?
Okay, no, you fine.
Pereza, got you. Don, got you. Hatmaker, got you. And Taylor Moore, got you. Yes, Stacy Tyson is signing in. All right, so we got 8 people signing in so far. I got you, Stacy.
Thank you.
It's 6 o'clock now. So everyone, let me see, Trenton Brown. All right. So everyone got the writing assignment, right? The announcement posted.
Yes.
Okay.
Yes.
All right. So we're not gonna talk very long tonight. We're only talking about one chapter. So we're not gonna be on here very long. Mackenzie Richards. Um, I got you, Mackenzie Richards. We're good. Signed you in. All right, so we're not gonna talk very long. I just wanted to make sure you guys got the first writing assignment, which you do Thursday the 17th. Um, so remember, y'all need to email that to me no later than 11:59 p.m. on Thursday. I remember, of course, I would prefer to have it in a Word document if you can. If you do not have Word, send me a PDF because a lot of times with the Google word processing app, a lot of times it won't let me. I have to have a password or get permission to get in or something like that. That's kind of nerve wracking. So just make it a Word document, please. If you can't make it a Word document, send me a PDF. I got you, Todd Ford. I'm still signing that, probably. Todd Ford, I just got you, so you're good. All right, so that's how I want to be writing assignments. So please email it to me no later than 11:59 p.m. It's still tomorrow. No later than 11:59 p.m. on Thursday, the 17th. Like I said, I want it to be a Word document. That way I can correct it and do everything on the same document and just send it back to you, or either a PDF. So I would prefer a Word document. All right, so let's talk very briefly about chapter 5. That's the only new chapter y'all got this week, chapter 5. Um, so chapter 4, remember we talked about the actus reus as the first part of the crime. So there is an act that has to take place. It's something you have to do. What we call it, I think the book called it a voluntary act. So something you do with your own volition. So it can't be something. It can't be something that is what I say done by hypnotism if there's a such thing, or done in your sleepwalking. It has to be something you mean to do. So it has to be a voluntary act or culpable omission. So a voluntary act, a culpable omission, and I know we talked about what a culpable omission is. When you're supposed to do something and you don't do it, or you have a duty to do something and you fail to do it. So that is a culpable omission. So that's the actus reus. How you doing, Ms. Woodford? Seems excited today. I got you checked in, Ms. Woodford. But so today that was the actus reus. That's the first part of the crime. So the second part of every crime, and this is the one part that every crime doesn't necessarily have. That's a special classification of crimes. But and we'll talk about those as well. But the second major part of crimes, two major parts, the two major parts, the actus reus, and then this is the first part. Then the second part is what we call the mens rea. The mens rea is the mental state. So with crimes, it's not just that you take an act, but it's you take an act with a certain mental state. If you do something on purpose, or what we call intentionally, that means you're doing something intentionally. Then you doing something reckless, knowingly. Then you can also be doing something recklessly, and then you can also do something negligently. Those are the four main categories of recognized by the model penal code for the mens rea, the four main mens rea, and that's something when you do something purposely or intentionally. We'll do something with intent. Then right below that is when you do something knowingly, which is a little bit less serious than intentional, because you're doing something not necessarily with the intent, but you're doing something having good reason to know that a certain result will happen or is likely to happen. Then you have recklessly is when you know there's a risk, that something bad will happen, but you don't care, and you do it anyway. And then there is negligence, where there is a risk, but you are kind of too blind or too stupid to realize that the risk is there, and you're proceeding kind of blindly, not knowing that someone may get hurt. So recklessly is usually when something is done on accident, where someone should have noticed or should have been paying attention. So I would say that's negligence. So negligence is when you walk in and you accidentally bump into somebody, or you step on their Jordans, and they're like, you stepped on my J's. Oh, my bad, I didn't mean to. I ain't see you standing there. That's like, watch where you going. That's negligence. Recklessness is when the room is tight, and and you don't care, you dancing, bumping into people, and ain't no room to walk, and you still stepping on people's shoes. So you're doing something knowing there's a risk that you can bump into someone or step on they brand new 11s, but you proceed anyway. That is recklessness. And knowing and when you do something knowingly, you know that based upon your actions that a certain result is going to happen, or is highly likely to happen, and you proceed anyway. And then, of course, doing something intentionally is when you do it on purpose. So those are the four main categories of mens rea. Of course, I went deeper into it in the lecture. Did everyone understand the lecture? Who all just signed in? That was Justice Hope, right? Someone signed in right before her.
Yes, it's me.
Jasmine Dudley too.
Jasmine Dudley. Who else? I just let somebody else in.
Me too.
Did you get me?
Jay Downs. I got you now. Downs, Dudley, Hope.
Tatiana Philomar.
I got you a while back, Miss Lamar.
Okay.
I feel like that was I got Trent Brown. There's a guy that signed in. Maybe no, it's only two guys on the call, Todd and Trenton. Not Todd, Trenton, and Cole. Yeah, we're good. Okay. So did everyone understand my lecture? Was it understandable? Could you hear it? Could you see it on YouTube? Was it straight? Somebody let me know. Or did you look at the lecture yet?
Yes.
Okay. So I'll take her yeses, everybody's yes. So I went through chapter 5, so we talked about the mens rea. So the next thing is not just that you commit an act and that you have a certain mental state when you commit the act, but when we talk about concurrence, concurrence means that that act and that mental state must exist at the same time. So at the time you commit the act, at concurrent with the act, there must also be that mens rea. So there's concurrence, meaning that they exist at the same time. So you can't do something with a certain mens rea or not purposely, and then later be glad that you did it. It doesn't count. So it has to be you. In other words, you have to have the mens rea at the time, simultaneous to the action, or to the actus reus. So that's what concurrence means. Then we talked about causation, which is another very, very important thing. I know I talked about it in depth in the lecture, but I want to make sure I get this in, kind of get this through your skull. Causation is very important, especially when we talk about what we call result crimes that are only those crimes if there's a result. So if I punch somebody in the face, and they live, it's just an assault, or a battery, intentional infliction of, I intentionally inflict harmful or offensive contact upon a person. That's an assault, or that's a battery. But if I punch somebody in the face and they die, then that can be a homicide. So it's not. So in other words, the result. So there's a specific result that goes with certain crimes that makes it the crime it is. So when we talk about homicide, that's when something happens where somebody dies. That means the result of any homicide means somebody is not here anymore. So in those result crimes, it's not just a matter of proving the actus reus and the mens rea, but it's proving the actus rea and the mens rea are concurrent, and that act and that mental state together were actually the cause of the death, of the result. So when we talk about causation, there are two levels of causation that have to be satisfied for a person to actually be legally the cause to be held responsible for a person's death. So let's say if let's talk about the two causes first. First, you have but for cause, or what we call cause and fact. So if I punch somebody in the face, I am the cause and fact of whatever injury they have when I punched them in the face, right? That means but for me punching them in the face, they wouldn't have ever had to go to the hospital to get stitches or whatever. So let's say I punch them in the face and they get, then they have to go to the hospital because they got a abrasion or something, and I punched them pretty hard or caused some damage. So now they got to get surgery or something like that. I broke their orbital socket or something. That's a pretty hard punch. But now they have to get surgery. So now they're rushed into surgery to fix their orbital socket, and in the surgery, the doctor makes a mistake, reads the wrong chart and thinks this is a heart surgery and not a surgery on the orbital socket, and the person dies as a part of what the doctor did wrong. So I am the but for cause. So but for me punching them in the face, they wouldn't be where they are, but it takes more than that. So it's the but for cause is the first question that has to be answered. So the first question you ask is the defendant the but for cause of the result of the crime or the result or the death? So if the answer is yes, that's not the end. That's not the end of the analysis. Next, you say, okay, if they are the but-for cause. Now, if they are not the but-for cause, that ends the question right there. That means they're not they're not liable or responsible for death. But if you answer yes and say yes, they are the but-for cause of, in other words, they wouldn't have been in that situation but for the act of the defendant. If you say yes to that, then you have to ask another question. And you say, well, okay, if they are the but-for cause, then are they also the legal cause, or what we call the proximate cause? So what's that mean? That means the legal cause or the proximate cause essentially asks, would it be fair to hold this person responsible for the death or for the result that occurred? So you ask yourself, was there anything that intervened that was not foreseeable? So it's all about foreseeability. So me punching someone in the face, and then them having to, of course, I know it's going to probably be an injury. But is it foreseeable that they'll have an injury where they're now going to have to get surgery? Is it foreseeable that the doctor would totally goof it up and do a heart surgery instead of the surgery on the orbital socket? Those are questions that would have to be answered. And then the question is that foreseeable? Now, it may be more foreseeable if if the person dies in the surgery and the surgery is on the right body part, but they lose blood or something like that and they die. Then you could say, well, it is foreseeable. It's possibly foreseeable. It's not necessarily outside of the realm of foreseeability that person would have had to get medical treatment. But then you have to say, well, what level of medical treatment is foreseeable? But those are questions you would have to answer in your analysis, like if you got something in your writing. So those are the two levels of causation. So they have to be the but for or cause and fact. So you'll hear me say cause and fact or but for cause. We use them interchangeably. And then you ask, if they are the but for cause and fact, then the next question you ask is, are they also the legal cause or proximate cause? So if the answer is yes to both of those, then they are responsible for the death or for the result, whatever, when we're talking about result crimes. So the main result crime I always talk about is the homicides, because of course the homicide that is the result is death. So in other words, can you hold this person responsible for this person's death? So let's say they are the but-for cause, but they're not the proximate cause. Does that mean they're off the hook? No, it doesn't mean they're off the hook. It just means they're not going to be charged with the homicide. It means they should probably be charged with an assault or a battery of some sort, because they did intentionally punch the person in the face, right? So they're going to be held responsible, but just not responsible. They're going to be held responsible for their actions. They're just not going to be held responsible for the death of that person. So that's how. That's how proximate. I mean, that's how cause and fact and proximate cause work together. So to determine whether someone is actually responsible for a death, you have to ask those two questions. So that is chapter 5, where we talk about the mens rea. We talk in chapter 4, we start talking about the actus reus, but you have to have the actus reus concurrent with the mens rea, so that's concurrent. So they have to exist at the time the act is taken. So when you take the act, you have to have, at the same exact time, you have to also have the requisite mens rea. And then we get to causation. Let's say if they're charged with the crime that has a specific result, like death, like homicide, then the question is this person both the cause and fact or but for cause and the proximate cause or legal cause? So those are questions that both have to be answered in the affirmative for that person to be found guilty. So does everybody understand that? Somebody answered. Somebody said something.
Yes.
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 Okay. So that's chapter 5. We only talked about chapter 5 this week because you guys also have the writing assignment that's posted. Remember, before I end this call, the writing assignment is due Thursday. So from now you have what today is. I guess there'll be 1 day, 2 day, 3 day, and the 4th day, into the 4th day. So you have a little bit less than 4 days to complete the writing assignment. So if you didn't start last Thursday, Shame on you, but you still got 4 days to do it. And you know, in law, it's a law school level question that I would have had in law school. And if you guys are interested in law school, a question like that, you'll have 30 minutes to answer it. So you literally have to do all this analysis stuff, run the stuff through your head, know the law to apply, and then apply the law, and answer the question in pretty much a 30-minute span. So I would say that might be like a bar, not quite a bar level question, but if it was on the bar exam, where I would have 6 essays. Hold on, how many essays we had? Yeah, we had 6 essays in the morning and 6 essays in the afternoon. So talk about doing 6 essays in a 3-hour period. That means basically you have and doing 12 essays in a day, in 3-hour blocks. That means you have pretty much 30 minutes to do each essay. So you really have to. That means you including the reading of the prompt. So the time starts when you crack the seal on the book, when they say you may begin, and you crack the seal and you start reading. Those are your essays. So if you split it up evenly, it's about 30 minutes per question. But I've given you guys a week. And Miss Orr, I got your message, Miss Orr. My condolences. Miss Orr.
Yes, I'm here.
Yeah.
Thank you for your condolences.
Is this a personal question about the paper, or there's something you want to ask, so maybe everyone can be enlightened?
Oh, so everyone can be enlightened. So I'm reading it, and it says, should the Supreme Court affirm or overturn, I can't pronounce that name, so I'm going to skip that. Overturn their conviction based upon the constitutionality of the Protect House Act. And then it says, please use prior Supreme Court precedent in the equal protection analysis to rationalize your response to this question.
Mm-hmm.
So I'm trying to figure out how to properly phrase my question, but I guess what I'm trying to ask is there a specific answer that you're looking for, or is it more so if we say something that you don't completely agree with, but if we prove?
Well, there is, in this question, it is a particular answer I am looking for.
Okay.
So, and I said use Supreme Court precedent. So remember we went over that there are cases in the first chapter of the book, the cases I went over in the lecture. So remember, so you might want to go to those cases, and of course, we talked about the equal protection analysis. So essentially, you're going to be using kind of what you learned in the second chapter to determine whether or not that law is constitutional. So the defendant essentially is challenging the constitutionality of the law itself. If the Supreme Court finds that the law is unconstitutional, that means they're going to overturn Mr. Yu's sentence. Or they're going to overturn his, I'm sorry, not his sentence. They're going to overturn his conviction. So essentially, I'm asking you whether or not I'm asking you what the Supreme Court should do based upon prior precedent that's been set by prior Supreme Court cases that you've read. So in other words, what I'm saying is apply the legal test and rationale from other Supreme Court cases. To answer the question. Is that clear?
Yes, thank you.
Yeah, so it's either gonna be constitutional, which means you do not overturn the conviction, or it's gonna be unconstitutional, which means Mr. Yu's conviction is gonna be overturned. That's essentially what that means. That's essentially, it's almost like binary code. Either it is or it isn't. So in this situation, this isn't one of those cases where it's all over the place, where you have to kind of throw an answer at me. This is an easier question because you can only select one of two answers. Where you get your hits at is why. When you start explaining why you got the answer, or you chose the answer you chose, and explaining yourself and applying the correct rationale. So
I have a question.
Go ahead.
Do you want us to use the IRAC method for this paper, or do you just want it to be like a 5-paragraph?
I would prefer IRAC or CRAC.
Okay.
So 5-paragraph theme is normally when you're doing a normal, almost like it's a persuasive essay writing format, but it's normally used when you're giving your opinion. as opposed to stating certain facts and applying certain laws. So or certain legal principles, or not even legal, just principles altogether. So if I was asking you your opinion, or who you think is going to win the NBA Finals this year, and you said the Lakers, you would use the 5-paragraph theme to explain to me why you feel the Lakers are going to win it all, and you would give me, you would break it down into 3 or more reasons. That's when you use the 5-paragraph theme normally when you're expressing an opinion. But in a situation where you're asked to answer a legal question, and apply a legal principle to answer the question, normally you want to use IRAC or CRAC. So you want to tell me what the issue is. So that means what the crux of the question is, or what we're trying to find out. Or if you want to do contention-based writing or CRAC, you can open up by telling me what you're going to do at the beginning. Either I'm going to overturn because it's unconstitutional, or I'm going to overturn or accept. I'm going to accept the conviction, or we're going to keep the conviction because it is constitutional. So you're going to open up by telling me that. And then you're gonna then under that that sentence or that first paragraph where you tell me what your contention is, or you tell me what the issue is. Then after that, and that next, when you move to your next paragraph, you're gonna tell me the rationale or the rule you're going to apply to answer that question. So you're telling me what the issue. You tell me what the issue is, or tell me what your contention is. Then you say, well, I'm going to apply this rule or this rule of law that comes from this case. And you don't have to quote cases and cite cases and stuff like that. So I don't need any citations or anything like that. But you can even verbatim give me the principle of the case. And you really don't even have to mention the case itself. You can. But I don't want you to spend a lot of time talking about one case as opposed to talking about the fact pattern I've given you at hand. So sometimes they can throw you off when you try to actually mention and talk a whole lot about the case, the precedent from a case. So you can kind of get mixed up and just focus on that and not answer the question, or not apply, or not really thoroughly apply the facts to this case in the analysis, if you know what I mean. So that's fine, but just make sure you kind of stay on course. So give me the rationale or the rule of law that's applied, or the standard you're applying. Then from there, you give me the analysis. And the analysis portion, that's once you give me the standard or the rule you're going to apply to answer the question, then you have to talk about what the facts in the case that help you answer the question. So, he did this, or the law said this, or the law said that, and this, it's not this, or it's not that. So therefore, then you're going to give me a contention again in your conclusion paragraph, where you say, in conclusion, either answer A or answer B, and a brief, maybe 2 or 3 sentence recitation of why, and then that's how you close. So like, it is boring, it is kind of redundant. So you're telling me what your answer is, or you're telling me what the issue is, telling me what rule you're going to apply, rationale you're going to apply to answer the issue, or tell me why you came to the conclusion or the contention you came to. Then you're going to tell me specific facts from the fact hypothetical that I gave you that help you answer the question or come to the answer, and then you're going to close by giving me the answer again. So therefore, or in closing, this is my answer. So is that understood by everybody? Anybody have any issues with that? If somebody has a hand up, I'm sorry.
So just to clarify, you said, can you repeat what you said about the citations? Like, that confused me.
You don't have to cite the case and write citation and do all that. It's not one of those research papers where you got to go cite sources and stuff like that. I just answer the question. So in law school, you're not gonna, when you're answering a question, the professor just wants to know that you learn the rationale or know the correct rule of law and apply it correctly and are able to write it, or convey it in a readable and understandable and very organized format. So it's not about citing sources. So you can mention the case, You can, you can mention the case you want to, talk about, but you don't necessarily have to write the whole citation and the case number and the year and stuff like that. So that's what I meant by not having to cite it. And you don't have to worry about citing sources. You don't have to have footnotes or endnotes at the end of your writing. Just answer the question. Is that a clear answer to your question, Ms. Orr?
Yes, thank you for clarifying.
Mm-hmm. So that's all I'm asking for. So I think unless there are not any more questions, I think that's all. So what's today? The 14th. So we've done this Zoom. So next week, next week's reading is going to be posted on the 17th as well. So you got something you're turning in on the 17th, and chapter 6 is also going to be available for your reading pleasure on Thursday as well. So, but of course, we're not going to talk about chapter 6 until the 21st when we do that Zoom. So just like I said, I've literally pre-planned everything. I got everything in your learning units, and I've timed it out to where it's going to be available exactly when it says it's going to be available per the syllabus. So as long as you guys have the syllabus, and that's why I color coded it, and so you know the difference between one class session and other class session. Yellow, white, yellow, white. That way you'll know what we're going to talk about. So right now we're right on target, right on schedule, so that we're not off of the schedule at all. So what you see in the syllabus is exactly what we're going to talk about. So expect chapter 7 to come out Thursday. So that'll be Thursday morning. And hopefully most of you guys by then would have emailed me your submission by the end of the day, Thursday, the end of the night, 11:59. Okay. So is everybody good? All hearts and minds
Yes.
clear?
Yes, sir.
Attorney Voice,
Yes, ma'am.
I have like two questions, one pertaining the assignment and one pertaining law school.
Okay.
The first question is for my issue statement for the IRAC writing. Is it okay to make my issue statement general and then go into the specifics
Yeah,
later?
that's all right. Especially now in law school, they may want you to have more of a tighter issue statement. But and it depends on what professor you're writing for. So in law school, that's another thing about for you guys that want to go to law school. You not only do you have to know the basics and how to IRAC and CRAC, but you also have to know what your professor likes. So the only way you're going to know that is to write for your professor throughout the semester. So when you get a block of information, find questions, and type answers to the questions, and then give it to your professor. See if your professor you can talk to your professor about it. So that way you'll know. That's why you really have to use those office hours in law school, because sometimes you can be perfectly right, but it depends on the subjective opinion of that professor, whether or not they value how you write. Some professors want a whole brain dump. So if you can, we call it a brain dump, because essentially you just let them know, everything about what they talked about over the whole semester. You're not necessarily hitting a narrow point. You end up coming to an answer, but you're almost like you're trying to get points by dumping everything, whether it's important or not. I had some professors that were cool with the brain dump. Other professors hated it. They're like, no, that's not. I need you to talk about this this issue that So of course, for this class, because you're learning, kind of in the learning phase of how to do legal reasoning and writing. I'm not going to be a stickler for that. So I want you guys to give me it can be a general legal statement, issue statement. It could be the issue is whether the Patriot Protection Act is constitutional, or that would be a decent issue statement. Of course, I won't want you to rob my swag like that, steal my issue statement. I'd be cool with it, but be creative, create your own issue statement. But that's a start. And what's the other question about law school?
So I was looking at Central's like scholarship things, and I know that you had went to Central for law school. Do they still do the thing where if you intern for the public defender's office down there, they'll give you a scholarship. Do they still do that?
That I do not know. I know because I didn't take that route. I just took out a loan. I did the old school way, and I still owe the government in 2020. It is what it is. Not gonna get out. You know, I got to pay that debt. It is what it is. That's what I did. So I didn't have no scholarship plan. I just owe Uncle Sam, but they'll get their money at some point in time.
Okay. Thank
But
you.
I don't know about those specific
No,
programs.
don't be. He's about to. We are. We are. You. No, you gotta warm it up.
Who that? Latia. Okay. Yeah, I thought you were arguing with me. I was like, who you talking to? What's going on? But All right. So there any other questions before we log out of here?
Can I speak with you after class or like after?
McFadden.
Who's that, Miss McFadden?
Yeah.
Yeah, just stay on. All right. You guys can log out if you're done.
Professor Boyce,
Yes.
did you get me for attendance?
What's that, Latia Williams?
Williams? Yes.
I did not. I got you now, though.
All right. Thank you.
Anybody else?
McFadden.
McFadden, I got you already.
Okay, thank
That's
you.
your question?
Yeah,
Okay, I got you.
thank you.
Anyone else? We all good? I can log out now? All right, I'm logging
I
out.
still needed to talk to you.
Oh, you need Miss Orr. Okay, y'all can log out. Y'all log out, quit being nosy.
I mean, it's nothing really. I mean, it's nothing.
I'm just joking. Go ahead and ask, though.
So with my grandmother passing, we are trying to make arrangements, and I'm trying to make travel arrangements. And so I don't like. It was a struggle today. Like I found out that she passed yesterday.
Mm-hmm.
And like me and my grandmother, she's actually my great grandmother, but we were extremely close. Like me and my great grandmother were closer than my mom and I are.
Yeah.
And it's extremely hard, and this is taking a big toll, and like trying to make, you know, her funeral arrangements and her memorial arrangements and trying to establish my travel arrangements. Like it's just very hard. And
Now,
so,
where are you from?
I'm from North Carolina.
What part?
I'm in Greensboro.
Oh, you're from Greensboro. Okay.
Yeah.
I mean, I know you're in Greensboro, but where are you from? Like, where when you go home, when you go to celebrate your grandmother's life, where will you be going? Local or?
Oh no, it's out of state.
Okay.
I think we're going to Virginia,
Okay.
but we might be going to Michigan. It just depends on.
I'm trying to get an idea, because I knew you probably have some travel, but with this class, you know, this is essentially our class meeting for the week right now. So, you know, at this point, just follow up with me via email. Let me know if you're gonna miss next week's Zoom or something like that. But really, all you got to worry about is the paper, which is not due, you know, until Thursday. And you know, if the plans run into the Zoom, just let me know. You know, so you gotta think that the only reason I'm even doing the Zoom to keep it real is because, of course, with the online classes, the campus doesn't want us as professors to be lazy and just drop off, you know, YouTube lectures and walk away from the course. I mean, it'd be easy to do that because I've already essentially taught the course via YouTube. So all you guys are doing is clicking links. But that would kind of be that would be lazy and terrible. I'd be essentially stealing a check and not being a good professor to you guys if I'm not available in real time. So they have essentially mandated that we have real-time classes with you guys. You know, like I said, I'm not doing a whole lot of lecturing on this Zoom because I've already lectured via YouTube, but at least want to talk about some stuff, make sure y'all understand the concepts in person. Because I don't know it's hard for me to know whether or not you get the lectures, right? Because you know, you just look at them, but I don't even know you're looking at it. So, I don't know if you got it or, you know, and you could have looked at it and still like, I don't know what Boyce is talking about. So that's why I want to give you guys the opportunity to have time with me in real time when we talk about it.
Right.
So, the university, but if the university didn't mandate it, I would probably still do it anyway, because I just think it's shabby to just, if this was a 5-week summer course, you know, when I'm doing that, I definitely drop YouTube, and if you got a question, just email me. But you know, you got to think, we together for like 4 months, from August through pretty much November, December. So I can't do that. That would be irresponsible as for me as a professor to just think about doing that over this period of time. So I was, that's why I just want to have regular meetings for each class. I teach 4 classes. This the only class you're in with me? I feel like I see your name on another roll.
Yeah, I have you for courts and judicial as well.
Okay, yeah. So yeah, we just meet once a week, and I think in courts and judicial process, that's tomorrow. I want to say all you got to worry about in there for the time being is like the discussion board, and I think there's a midterm, but that's not until October. I think all we got in there is we got discussion boards and a midterm, and that's it. I want to say that's it. So at this point, as long as you are adhering to your syllabus, don't worry about anything. If you can't make a Zoom, just let me know in advance so I'll know to go ahead and mark that you're excused and you're good. I understand bereavement. So I understand fully. So I'm not trying to give you a hard time at all. Just communicate with me. And I would say definitely communicate. So it's not even just about me. Communicate with all your professors. Okay.
Right. I was gonna send out an email tonight. It's been very like physically and emotionally draining.
I definitely
Like
understand that.
it was a lot. Like getting out of bed today was extremely hard. But
Hey, it's called grief. It's called grief, and there's nothing wrong with admitting it. So there's nothing wrong. Grieving is actually, I feel like it's an actual physiological condition. I think we play it to the side a lot, like he's just sad right now. No, it's grief, and actually you can have physiological responses to grief. People get sick, can't keep food on their stomach, lose weight, and actually get health conditions because they don't handle their grief the right way. So there's nothing wrong with being weakened. Of course, I've lost important people, and it just is what it is. So you don't have to apologize or explain yourself to anyone. Only thing you owe us, because you're in our classes, is communication. So that's the
right.
only thing you owe us. You don't have to explain what's going on, or we believe me, I've lost important family members, and I understand the pain. So you don't even have to go through that with me. But please just let me know. Don't get missing. And then, and I'm like, well, all you had to do is tell me. You didn't have to explain to me, but all you had to do is email me. That would have been good.
Right.
All right. So,
One more question for you.
mm-hmm.
So we don't need outside information, right? Because you said we don't need citations. So does that mean that you don't expect us to use outside information, or is that just?
Yeah. All you need to use is what you learned thus far in the semester and in the book.
So the book and your lectures.
Yeah, the book and my lectures, and even my lectures are pretty much straight book. I add a little bit of stuff to it, but what I lecture on is easily found in the book. And if some stuff may be outside the book because I use some examples, but between my lecture and the book, I've given you the basis to answer the question.
Okay, I was just asking because I've never done an academic paper like this without citations, so this is going to be new for me. So please bear with me.
This isn't a paper. It's an essay. So there's a difference between a paper and an essay. Normally, this would have been something back in when I first started teaching back in 2012. This would have been a part of like a essay portion of a final exam that I would have given and been in the room. But it might have been an open book or something. But I realize that's kind of unfair for people. You're in. You don't even necessarily know, and you haven't been taught the principles of legal writing yet. So I'm kind of teaching, and so I can't have you guys have to sit down in a test environment and do that in the third. So I'd rather give it to you as like a take. So don't think of it as a paper. It's a take home essay. So you answer it like you would answer. It's an essay question. It's not a research prompt where you have to give me some thesis and all this stuff, and then give me quote the citations or stuff like that. It's not, none of that's necessary. Just answer the question.
Right, gotcha. Okay.
Right.
I'm still a little confused about like what an essay is, but thank you.
Yeah. So think of it like this: an essay is So you said, I think in North. So you went to from elementary school all the way through high school in North Carolina.
No, in elementary school I went to school in Virginia Beach, but
okay. So
middle school and high school I was here.
So in North Carolina, the reason I know the 5-paragraph thing is I was taught it in 4th grade. So in North Carolina, they actually had a standardized writing test. It wasn't multiple choice. It was just how fourth graders wrote. So by the time we got to fourth grade, that's what we did. We probably wrote an essay a week almost, because they were training us. Some students I graded highly on it, so I've always been a good writer. So I never forgot those principles. So pretty much an essay, let's say if I was to, like I was saying before, who do you think, if I ask you who you think is going to win the NBA championship, or who you think is going to win the Super Bowl NFL this year, you may have a team, right? And you may think you know who's going to win it because you know football or you know sports. An essay is nothing more than answering that question in writing and in a very organized manner of writing. So if you think it's going to be LeBron James and the Lakers, tell me why. The three, and so the 5-paragraph theme is saying, you have your thesis statement, or like if it was Iraq, it would be that contention statement. So you have that contention or that thesis statement. LeBron James and the Lakers are going to win the 2020 NBA Finals. They're gonna win the 2020 NBA Finals for 3 reasons. The first reason, they got LeBron James on their team. Second reason, they got Anthony Davis on their team. The second reason is they're well coached and they got a good supporting cast. So those are 3 reasons, right? So what happens is your first paragraph is just about stating your contention and telling me that the 3 reasons why, and then saying and this is why I believe that that the Los Angeles Lakers are going to win. Now, then you break it down. Each paragraph is one of the reasons. The first reason, so you move to the next paragraph, which is the second paragraph after your thesis paragraph. In that paragraph, you say, okay, the first reason why the Lakers are going to win the championship is because they have LeBron James. He's the greatest player on earth right now. And here's why. You list his stats and tell us why he's great. And that's a whole paragraph in and of itself. You probably 7 or 8 sentence paragraph. That's a lot of sentences for a paragraph. That's a big paragraph right there just on LeBron James. Then you end that paragraph by saying, and that is the first reason why they're going to win. Then the transition or move to the very next paragraph and say, now the second reason why they're going to win is because they also have Anthony Davis on their team. Anthony Davis is blah, 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 blah. He's 6'11". He's won Rookie of the Year before. He's the most versatile big man in the NBA. He played point guard before, hit a growth spurt, and shot up to 6'11", but still has all the skills of a point guard. You can tell me all this stuff about Anthony Davis, and then end by saying, and once again, that is the second reason why, on top of LeBron James, why the Lakers are going to win the championship. Third, then you say, now the third reason why the Lakers are going to win is the NBA championship is because they have a great supporting cast. They have bench players, they have role players. You can start to name those players and what they do for the team. So that's now your 4th paragraph, right? So you're 4 paragraphs into a 5-paragraph theme essay. Then you end by saying, in conclusion, and you're almost restating that first paragraph again. In conclusion, the Lakers are going to win the NBA championship because they have LeBron James, they have Anthony Davis, and they have a great supporting cast. I don't see who can guard LeBron James. I don't see who can handle AD as their 1-2 punch. And the other guys they have on the team to support and step up in big moments is going to make them unbeatable. Therefore, they are unbeatable. So you see how that's the organization of a 5-paragraph essay. So you see, so you didn't necessarily. So now you can. This isn't a research-based writing, so you don't have to give me citations. I just want to know that you're using the correct rationale. You feel me? So I'm more worried about the rationale and the rule you use. But I know where you got it from because I taught you. So you're not having to say all that again for me. Now you can say this case, state the name of the case and tell me a little bit about what happened and why they may kind of be the same or similar or not quite the same. And then move on from there and tell me, but in this case, it's not going to, because this case is slightly different. The law is going to apply like this, and therefore it's constitutional, or therefore it's unconstitutional. So you may have to do a little bit of that. So It's not a, you don't have to cite your sources, or cite. You can mention cases, but I'm not looking for citation. So it's not it's an essay. It's not a research paper. So did that make it more clear, or did it make it more fuzzy?
Yeah, that made it a lot more clear.
Okay. So yeah, that's all I'm expecting. So just so in other words, treat it like an essay. You know, and I don't know what you're the expert in or what you know about. You know, I just use basketball and football, but that's my thing. But anything you're interested in, think about if someone asks you a question that you have a strong opinion of, right? Like,
Right.
what's the greatest HBCU on earth? HBCU on earth. I'm assuming you're gonna say A&T, right?
Of course I am.
So if you're gonna say A&T, I'm assuming you can write an easy 5-paragraph themed essay on why A&T is the greatest, right?
Yeah.
Yeah. So imagine now spewing those feelings out, but you're not you. So the reason we call it the reason we have 5-paragraph theme writing and we have IRAC writing and legal and on the legal side and CRAC writing on the legal side is so that you can organize your thoughts. So it's about an opinion or a contention that you're supporting. So you know why A&T, you know why you feel A&T is the greatest school. So you got to tell everybody else, but you can't tell everybody else in an unorganized manner, or they won't get it, right? So you have to pinpoint. Here, I got 3 main reasons why A&T is the greatest, right? You pinpoint those reasons, and you just like I did with LeBron James and the Lakers, you can do the same thing in a 5-paragraph theme. That's how you do what I call persuasive. What do you call it? Opinion-based persuasive essay writing. But legal writing is different because it's more contention-based. So it's contention that has to be supported by some type of rationale or law. So it's different. So you're not just running me 5 paragraphs. You're giving me a contention. Then you're telling me what rule you're going to apply. In other words, this is what I believe, and based upon this law, this is why I believe it, and this is the law that I'm going to use to apply to these facts. And then after that, based upon what happened in the hypothetical, in this case, this is different or this is the same, so therefore, that's your answer. So all it is a means of organizing your opinion or so this isn't opinion-based writing. This is contention. So with this essay, this is a contention. So it's different from you saying why A&T is the greatest, because we know why A&T is the greatest, but there's not necessarily a law, right?
Right.
That's our opinion. But in legal writing, you're giving a contention, not necessarily an opinion, that you're contending that this is what it is and here's why. And like I said, even without writing, I do that in court every day. I do it when I'm talking to an opposing lawyer, or the DA about a case and why they should dismiss or why they should offer my client something lesser or reduce it. So I'm stating the contention, but I have to have law and facts to support my contention. So this is what you should do for my client, and here's why. So the law says that, this is the law. The law says blah, 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 blah. Based upon what your rendition of the facts or what the cop said in his report, my client couldn't have been there, or my client might have been there, but their actions were mitigated because this is what the officer said in their report. And for the rest of your life, and if you're going to be in law school, going to be a lawyer, it's always going to be about facts. It's always going to be about knowing what the law is and then knowing what the facts are and applying the law to the facts to figure out what the outcome should be. So that's all you're doing in this legal essay, in legal essay writing. So you have to organize your thoughts, or other people won't get it. So you can have an opinion all you want. I mean, you can have a contention all you want to, but if you don't have a rationale or a basis to base your contention off of, and you don't have a rule of law to tell me that you're applying to it, then your contention is baseless. So that's legal writing. Give me a contention, or if you don't have a contention and you just want to tell me what the issue is and then get to a conclusion at the bottom, you can do it that way. So contention-based writing is when people start their writing and they know what they're, based upon, they know what the answer is going to be right away. Oh, that's the answer right there. I know, and this is what I'm going to apply. That's contention-based writing. So when it's not so clear to you, you might want to use issue-based writing. So instead of telling me what your contention is, tell me what the issue is. So in the hypothetical at hand, right? The issue is whether or not the Patriot Protection Act is constitutional. So you know, and that's the question you're answering. Whether or not the issue is whether or not the Patriot Protection Act is constitutional based upon whatever. That's an issue statement. So you're not giving me a contention or answer in the issue statement, right? But you're telling me what the issue is. That means as the reader of your writing, within the first two sentences, I need to either know what your contention is. I need to know where we're going, because this is what your answer is going to be. Now I just want to read the rest of the paper to see what the basis of your contention is. Or if within the first two sentences, I need to see an issue statement. So I need to know this is the issue. This is what I'm going to be reading about. Now let me read the rest of it. Let me read her rule of law to see if she's applying the right rule or rationale. Then let me look at the facts to see how she's applying the facts. And now let me look at the contention. So it almost makes it a little bit, with contention-based writing, is definitely predictable because you already told me what your contention was. So once you tell me what your contention was, I'm expecting certain things in your writing. So if you have a contention up here that says it's constitutional, you can at the bottom, when you get to your conclusion, say it is constitutional, right? So the bookends have to match. With issue-based writing, because you're just giving me an issue statement, you're not giving me a contention. As long as your answer is applicable to the issue, that's all that matters. But you have to have a contention at the end. So you can't finish your paper and not give me an answer at all. So you know, it's either this law is constitutional or it's unconstitutional, and you have to answer that question. You have to determine whether you're going to answer it in an issue-based writing or contention-based writing. So is that better?
Yes.
All right. Any other questions? Anybody? Cole, Zaria? I guess not.
I'm okay. I don't have no questions.
Okay. Y'all, Cole and Zaria stay. They're trying to get that knowledge. I ain't mad at y'all. Get that knowledge. So as long as all hearts and minds are clear, is everybody good? I don't want to leave this call without everyone having every possible opportunity to get answers from me. Not the answer to the question, but answer to your question. You got to answer the question, that's on you. Okay?
Thank you, Dr. Boyce.
All right, y'all be good. And
Thank
I
you.
look forward to getting them papers Thursday. Be on time.